Dear students, today we shall be discussing the nature of standard form contracts, why they are called so, and what are the issues and challenges associated with standard form contracts. We shall also be learning the rules for protection against exploitation of a weaker party in relation to standard form contracts, which have been propounded by the common law courts. Let us have a look at what standard form contracts are. These are contracts which are drafted by one party and signed by another party without any modification or change. These contracts are generally used by big organizations or big businesses that enter into numerable contracts on a day-to-day basis, and for that reason cannot conveniently enter into a negotiation with each and every party every time they wish to enter into a contract. For this reason, they keep a pre-printed standard format and essentially do not involve negotiations. That is why they are also referred to as take it or leave it contracts or boilerplate contracts or contracts of adhesion. These contracts are criticized for killing the bargaining power of the weaker party and open up wide opportunity for exploitation, particularly when it comes to exemption clauses. The terms often portrayed in fine print are drafted by or on behalf of one party to the transaction, the party with superior bargaining power, who routinely engages in such transactions. With few exceptions, the terms are not negotiable by the consumer. Standard form business-to-consumer contracts fulfill an important efficiency role in the mass distribution of goods and services. These contracts have the potential to reduce transaction costs by eliminating the need to negotiate the many details of a contract for each instance a product is sold or a service is used. However, these contracts also have the ability to trick or abuse consumers because of the unequal bargaining power between the parties. For example, where a standard form contract is entered into between an ordinary consumer and a salesperson of a multinational corporation, the consumer typically is in no position to negotiate the standard terms. Indeed, the company's representatives often does not have the authority to alter the terms, even if either side to the transaction were capable of understanding all the terms in the fine print. The danger of accepting unfair or unconscionable terms is greater where these artful drafters of such contracts present consumers with attractive terms or shopped terms of most interest to the consumers, such as price and quality, on the visible side, but then slip one-sided terms benefiting the seller into the less visible fine print clauses least likely to be read or understood by the consumers. In many cases, the consumer may not even see these contracts until the transaction has occurred. In some cases, the seller knows and takes advantage of the knowledge that consumers will not read or make decisions on these unfair terms. Now we shall move over to certain issues which are generally involved with the standard form of contracts. Firstly, consent. In the case of commercial contracts, courts have repeatedly held that contracts, even if entered into the standard format, are meant to be performed and not to be avoided unless it is shown that consent is obtained by fraud, mistake or duress, though they may be of an unequal bargain. Thus, where the parties with equal bargaining powers have fairly consented to the terms of the contract without any fraud, duress or mistake, courts have refused to interfere. The second being unfair terms of the contract. Courts have looked into the terms of the contract in relation to the bargaining powers of the parties and have interfered in cases where the bargaining power of the parties was not equal. In Life Insurance Corporation of India versus Consumer Education and Research Centre and others, the Honourable Supreme Court has held that if a contract or a clause in a contract is found unreasonable or unfair or irrational, one must look to the relative bargaining power of the contracting parties. In dotted line contracts, there would be no occasion for a weaker party to bargain or to assume to have equal bargaining power. He has either to accept or leave the services or goods. In terms of the dotted line contract, his option would be either to accept the unreasonable or unfair terms or forego the service forever. With a view to have the services of the goods, the party enters into a contract with unreasonable or unfair terms contained therein, and he would be left with no option but to sign the contract. Lastly, unconscionable nature of the contract. Basic test of unconscionability of contract is whether under circumstances existing at time of making the contract and in light of general commercial background and commercial needs of particular trade or case, clauses involved are so one-sided as to oppress or unfairly surprise the other party. Courts of equity did not share the reluctance of common law courts to police bargains for substantive unfairness, though mere inadequacy of consideration alone was not a ground for withholding equitable relief. A contract that was inequitable or unconscionable, one that was so unfair as to shock the conscience of the court, would not be enforced in equity. Now we shall discuss some of the protective devices or defenses propounded by the courts so far in order to protect one's interests in cases of such contracts of adhesion. First is a reasonable notice. In the first place, it is the duty of the person delivering a document to give adequate notice to the offeree of the printed terms. Where this is not done, the acceptor will not be bound by the terms. For example, there was a House of Lords decision in a case called Henderson v. Stevenson 1875, in which the plaintiff bought a steamer ticket, on the face of which were written the words Dublin to Whitehaven only, and on the back of it were certain conditions, one amongst which was an exemption from all liability clause. The plaintiff did not see the back of the ticket, nor was there any indication on the face about the conditions being mentioned at the back. The plaintiff lost his luggage on the shipwreck and was entitled to recover his loss from the company. The House of Lords said that the plaintiff could not be said to have accepted the terms which he had not seen, of which he knew nothing, and which is not in any way ostensibly connected with what is written upon the face of the contract. The result would have been different if the face of the ticket had mentioned words like "for conditions see back." Secondly, notice should be contemporaneous with the contract, which means that notice of the terms should be given before or at the time of entering into the contract. Notice that is rendered subsequently shall indeed amount to modification of the original contract and will not bind the party. For example, a man and his wife hired a room in a hotel and paid a week's rent in advance. When they went up to occupy the room, the notice was found hanging on the wall stating, "The proprietors will not hold themselves liable for any articles lost or stolen." The property having been stolen owing to the negligence of the hotel staff, the defendants was held liable, as the court said the notice was not part of the agreement. Third is the theory of fundamental breach, which is a method of controlling unreasonable consequences of wide and sweeping exemption clauses. Even where adequate notice of the terms and conditions are given in a contract, the party imposing the conditions may not be able to rely on them if he has committed a breach of the contract, which can be described as fundamental. An easy illustration for this can be one where a car was being sold on as-is basis and without any guarantee or warranty whatever. Even then, the seller was made liable when 5 days later the engine of the car blew up. It was not a car which was delivered, and hence the contract was fundamentally broken. If the car had shown any other defects which a used car is to everybody's knowledge likely to develop, such as for example a transmission problem, it would not have been regarded as a fundamental breach. Last is called strict construction, whereby clauses are construed strictly, particularly where a clause is so widely expressed as to be highly unreasonable. Any ambiguity in the mode of expressing an exemption clause is resolved in favor of the weaker party. In this light, it becomes important for us to know as to what is the rule of Contra Preferendum. Contra Preferendum, a Latin term which stands for against the offerer, is also known as interpretation against the draftsman. It is a doctrine of contractual interpretation providing that where a promise, agreement or term is ambiguous, the preferred meaning should be the one that works against the interests of the party who provided the wording. The doctrine is often applied to situations involving standardized contracts or where the parties are of unequal bargaining power, but is applicable to other cases as well. The doctrine is not, however, directly applicable to situations where the language at issue is mandated by law, as is often the case with insurance contracts and bills of lading. The reasoning behind this rule is to encourage the drafter of a contract to be as clear and explicit as possible and to take into account as many foreseeable situations as it can. Additionally, the rule reflects the court's inherent dislike for standard form or take it or leave it contracts. The court perceives such contracts to be the product of bargaining between parties in unfair or uneven positions. To mitigate this perceived unfairness, legal systems apply the doctrine of Contra Preferendum, giving the benefit of any doubt in favor of the party upon whom the contract was foisted. Some courts, when seeking a particular result, will use Contra Preferendum to take a strict approach against insurers and other powerful contracting parties, and to go so far as to interpret terms of the contract in favor of the other party, even where the meaning of a term would appear clear and unambiguous on its face. I hope by now you all are quite in a position to understand the nature of standard form contracts and also the challenges these contracts bring with themselves. As students of law, it is very important for you all to make yourselves clear with the defenses available in cases involving such contracts. With this, I shall conclude today's lecture. Thank you.